Ernest, in Arizona, what has to be proven before a bad outcome becomes malpractice instead of just an unfortunate complication?
Yeah, so bad outcome does not equal um, malpractice, right? When we're talking about humans, we're talking about biology, we're talking about physiology. Everyone's different, and biology is a weird thing, right? You could perform the same procedure on two different people and get two different outcomes, even if they had the same underlying condition. We don't always know exactly what's going to happen, and sometimes procedures just don't work, and you get an outcome that you didn't want. It does not necessarily mean that someone did something wrong. What you have to do to determine, or what you have to do to determine whether there's malpractice is basically determine whether that bad outcome was a result of someone in that treatment process doing something wrong. So you just have to match the bad outcome to a bad decision or a bad act or a failure to do something. Once you can establish that that was the cause, that failure, or that wrong act was the cause of the bad outcome, then you have malpractice. You don't just have bad outcome.
So, in medical malpractice cases, we often talk about the standard of care. What do we mean by that?
Yes, standard of care is just a term of art that's used both in the medical community as well as the legal community. And really, standard of care is just a word for, or another word I would use for it is a rule. It's a standard, right? It's a standard of conduct set for, let's say, physicians, if we're talking about physician malpractice. So, so what you would do is you would look at your circumstance, whatever that may be, and the question that you would ask is, what would a reasonable physician in the same or similar circumstance have done or not done? And if your physician didn't act as the reasonable person or the reasonable physician in that same or similar circumstances, then they have acted outside the standard of care. They've violated the rule, right? Because the rule is always, let's say if it's a surgeon, the rule is always to act as a reasonable surgeon in that circumstance. If they didn't do that, that's the rule they violated. That's the standard they have broken. So that standard of care is basically just that rule of how a person should act in a given situation.
And is that standard of care written down like a list of steps that a doctor has to take when they're performing a surgery, or is it a little bit more amorphous than that?
Yeah, that's where it gets complicated, and that's really why you need lawyers involved in this because sometimes yes, sometimes there are very bright line clear standards as to what should be done in, circumstance X. And we can go to a medical textbook and we can look it up and we can talk to a physician professor who says this is what is taught in medical school, this is what is expected. Sometimes you can go to, governing medical bodies or even statutes that will say exactly what's supposed to happen. But often that's not the case. Often it comes down to what I said before, which is what a reasonable physician in the same or similar circumstance would do, right? And so the way that's established is through expert testimony. So you bring in another physician in the same field who comes in and says, in this circumstance, here's what a reasonable physician would do. This person didn't do that. So when you say, can I look up that standard of care? Can I just go find a rule book? Sometimes, yes, depending on what the malpractice is and depending on what the circumstance is. Sometimes it's not necessarily written down. It's just a standard within the community of physicians in the same field. And so sometimes we have to get expert opinions in order to establish what that standard is.
What are some common situations in Arizona where a patient knows that something went wrong, but they're not sure whether or not a malpractice claim actually exists, and what should they do in that case?
Yeah, John, that's a great question because those are very often the calls that I get, which are, hey, I had this procedure or I had this treatment. this was the outcome I expected, but all of these sort of catastrophic or terrible things happened. And there's sort of a laundry list of, somebody didn't call me back afterwards, or a whole laundry list of complaints. And we have to sort of sort through that and try to figure out, okay, well, is there malpractice and where was it? So very often those are the questions that were presented. And really that's exactly the reason that people need to call. Unfortunately, I'm afraid a lot of people don't call because of that, because they sort of look at the circumstance. It seems very confusing. They think, okay, well, there's a bad outcome, but sometimes bad things happen. It doesn't necessarily mean anything went wrong.
Right. Just got unlucky.
That's right. But you're never going to know, especially if you have doctors or providers that are being cagey about the answers that they're giving you. You're never going to know unless you investigate it yourself. And frankly, that's why, lawyers are here. That's why people like me exist. So really, I mean, people need to call when they have those questions. We don't mind getting that call where they just say, look, here's all the bad things that happen. I don't, and we ask those questions like, what do you think they did wrong? And sometimes they say, well, I don't know. That's okay, right?
Mhm.
We're going to ask you what you think went wrong so we can sort of hone in maybe a little quicker. But if you don't know, that's all right. Come talk to us anyways. And don't be that person that just doesn't call because you figure, I just drew the short straw. If you suspect it, give us a call. It's what we do. We'll figure it out. In the end, you might find out, yeah, it was just a bad outcome. I was unlucky. But you might find out that there was serious malpractice that took place. And I'm afraid there's a lot of folks that just and, endure and live with the consequences of malpractice because they just took people at their word that, this stuff just happens. There's nothing wrong with calling and finding it out. Nobody on our end is going to ridicule you because you don't know exactly what went wrong. We know you don't know what went wrong. We can help you find those answers, and we'll help you find the right answers. So people need to act on that.
Is it important to act on that, very quickly? In an Arizona malpractice case, is early case investigation a big, an important step?
100%, John. It's very important in Arizona. Arizona has a short statute of limitations. It's 2 years. 2 years from the event. You have 2 years to file a lawsuit. A lot goes into filing a lawsuit, and we need time to investigate before we're ready to do that. And frankly, we need time to investigate, potentially make demands, and resolve your case without ever filing a lawsuit, which is ideal. That's even better than having to go through a lawsuit. So, yeah, the earlier the better. A lot of folks end up, um, not having a case because they wait around and they try to get answers from the doctors, and then they end up calling a lawyer, a year and a half, 18 months, 22 months down the road, and then they call lawyers, and these lawyers will just turn them down right out of the gate. Hey, the statute's in 60 days. I don't have time to get your records and review them in the next 60 days, let alone review them, hire an expert, figure out what went wrong, and start making demands or filing a lawsuit. So even though you have 2 years, if you wait 22 months, 23 months, 20 months, you put your lawyer in a very bad situation. A lot of lawyers won't even bother looking into it when you come to them that late. We try not to do that. If we think that there's a way, you come to us and it looks like there's a good case, we think we can do it in short order, we're going to do our best for you. But it's not a good situation to put yourself or your attorney in. So, as soon as you suspect malpractice, contact the attorney. It's a lot better situation to be in where we're saying, hey, okay, got it. Hold on. We know you've got an appointment with a specialist next month. Go talk to that specialist, raise your concerns, see what answers you get. Call us back in a month after that appointment. Let's
Mhm.
talk again. Let's start investigating. I would much rather be in that situation where it's like, I don't know, let's kind of see how things are going. Let's get some more information than, wow, it looks like you have a great case, but I can't even look at your records and your statute's going to expire in 2 weeks. You so
Right.
yes, so call early, bring your questions. Lawyer's never going to be mad at you for coming too early.
And finally, what should an Arizona patient or their family do to help to preserve records or names or timelines and other evidence like that?
Journal right from the beginning. Take notes, take times, take dates, write down the name of the nurse that walked in the room, when you talked to them, what they said, the time, the date, the name of the doctor, all that stuff. Journal all that stuff, but do it. If you start doing this when you suspect there's potential malpractice, do it with an eye towards litigation. Because the difference between whether we can keep those privileged in Arizona, meaning they're just between you and me as your lawyer, or whether we have to turn them over, is going to depend on the purpose for which you took those notes. So always just, even if it's in your mind, I'm going to take these notes because I'm going to talk to my lawyer. Write down those notes. Don't share them with anybody. And then that'll help preserve your memory. If you have to testify later on, you'll have something to review before you go testify. It'll help your lawyer with the facts of knowing what questions to ask going forward, what records to look for, what to look for within the records. So, and then make sure that you're doing it for your lawyer and that you're not sharing it elsewhere. I would much rather you bring a big journal to me that I can look at and say, okay, well, this is privileged and confidential. This helps me prepare your case. And maybe I'm going to disclose it because it's helpful, or maybe I'm just going to use it as a playbook. That's a better option than, well, I have to turn it over and we're going to deal with it no matter what's in there.
So you're saying that by doing it intentionally and thinking to either thinking to yourself, "Hey, I'm making these notes for my lawyer," or even maybe jotting at the top of the page, notes for my lawyer or something like
Yes.
that. That's what will allow it to have that attorney-client privilege, where you don't necessarily have to share it unless you think it's helpful for the case.
That's right. And I love the way you put that, John. I wish they'd all write notes for my lawyer on top. That's a great way to do it. Notes for my lawyer, write it down, don't share it with anybody. That gives me the option to either hand it over if we're in litigation to the defendants or not. And so, yeah, and it helps you preserve your memory. And then again, just contact the lawyers early. Those two things are going to be extremely helpful for your case.